Let me begin with one of the amazing moments that I've had. Right, so I'm going to talk about an extraordinary journey. Let me talk to you about one of the amazing moments, one of the many amazing moments that peppered this journey. It's a journey of 20 years. It's a journey which saw the decriminalization of gay sex last year by the Supreme Court of India. And I'll call this the Dakshaben moment. So Dakshaben was a lady who used to come and clean our little offices. We were a group of non-profit lawyers working in Flora Fountain for several years with the rejects of society. People who didn't have access to justice or legal aid of any kind were the ones that we used to provide services to. And we were doing this in the context of a really problematic epidemic, the HIV and AIDS epidemic, which was actually, there was a fear that India was going to be seriously impacted by. And so we had HIV positive people coming into office every day, and we had sex workers coming into office from Kamatipura, and we had gay men and queer women and hijras every day coming into office for legal aid and advice in this small little office in Flora Fountain, where there were photocopier shops outside and Irani cafes, etc. And in this context was Dakshaben coming in at 9 every morning to clean the office, make chai for all of us, and carry on her way to the next job. She was a character. She got along perfectly fine with me. I used to run this organization, this section of the organization. And Dakshaben actually obviously had seen the goings on in office. She was with us for at least 10 or 12 years by the time this moment happened in 2007. And in this moment, she actually came to me and said in Gujarati, "Tame jara bahar aao, so mane baat karvi chhe. Can you come out? I want to talk to you." I thought actually that there was some rumblings of discontent in office, which she wanted to handle with me, but extraordinarily not. She actually wanted to introduce me to someone, which she did. She went on to proceed to do in that by-lane. And this was a person, Mara Mitra, she said, my friend, and she said it in deeply bashful tones, but with irrepressible delight and utter joy. This was a woman, a large safari suit-clad woman with a crew cut, very masculine, a tempo driver, and clearly the love of Dakshaben's life. Dakshaben, a middle-aged mother of two, was actually sharing with me this deeply intimate moment and this deeply intimate and tender emotion of love, because she'd realized over these years that I was queer and that she could actually talk to someone like me about this, because this was an organization she was coming to every day and actually finding that there was openness here and there was an ability to actually be who you were. And this was who she was, and she was sharing that with me. And I thought that was just such a deeply powerful thing. Remember the context in which, of course, Dakshaben is, of course, living. What it signified to me was, of course, that we were actually, a space which was open and able to actually let people be who they wanted to be and create the comfort for her to express herself. But there was something else that I actually was picking up, which was that we were trying to convey the problem with Section 377 of the Indian Penal Code, the section of law which I'm going to come to in a second, and the oppressive nature of it for LGBTQ Indians. We were doing this through a court case, which I'm going to come to too, but we were doing it in a manner by which we actually began these huge discussions within the queer community about the problematics of this law and how it criminalized an essential part of our beings. And obviously this was having an impact in places we least expected, even with people like Dakshaben who were not necessarily politically involved, etc. But clearly we're hearing the murmurings of conversations in office, and there were clearly conversations which were happening and permeating through society. I think for me it symbolized the way in which we were able to fight this case in a pretty extraordinary manner, not in a manner in which a regular litigation is fought. There's been an impression given in the last year or two that this case was won because a few gay people went to the court and actually their lawyers represented them and arguments were made and there was victory at the end of the day. This is not accurate, really speaking. What is accurate is about what happened outside the courtroom as much as what happened inside. And I'm really going to try in the next few minutes to give you a little taste of what happened outside the courtroom. Because inside the courtroom, as you can imagine, there's lawyers arguing, there's books being opened and read from, there's submissions being made, there's judges sitting on a pedestal, there's a gavel to bring silence, there's sometimes a witness stand where cross-examinations take place. That's pretty much some of what happened in the courtrooms with 377, but there was a lot else which actually took place, which was quite fascinating. I think for that, before I get into that, I need to explain to you what Section 377 is. I imagine that many of you know what it is because it's been in the focus of media for a while now. But Section 377, essentially, these are the words of the section. Whoever voluntarily has carnal intercourse against the order of nature with man, woman, or animal shall be punished with imprisonment. So this is an 1860 law the British brought along. And essentially, it talks about voluntariness. So it talks about consensual sex. It does not distinguish between minors and majors. Adults who are having consensual sex would be captured under the law. And it talks about non-procreative, against the order of nature, which essentially has been interpreted to mean sex which is non-procreative. And therefore, gay sex was very much within the framework of that section. It was deployed against gay people. It was used threateningly all the time against hijras on the street, against gay people cruising in the parks of Bangalore and Bombay and elsewhere. And there was actually case law to show that this was a law used against largely gay people, not against straight people who were having non-procreative sex. So this was the law. It was a problematic law because there were clearly rights which were being impinged. The ability of gay people to actually enter into consensual relationships with others, adult queer people, was something that was not possible. And therefore, NAS Foundation, the NGO in Delhi which worked on HIV and was actually working with gay communities on providing health services to gay communities in Delhi, said that this law is actually not just impacting the right to health, because we can't distribute condoms in these communities, but it's impacting a whole variety of other issues, including the right to equality, the right to freedom of speech and expression, the right to privacy, the right to life and liberty itself. And so we as lawyers, and this was the NGO that I described to you a little earlier, in Bombay, as lawyers, were the lawyers who fought the case for NAS. And we filed this case in 2001. What we did not expect was a backlash from within the gay community about why we filed this case at that point. I can't get into the details of it because I have a limited amount of time to speak. It's an interesting story in itself, but I've written about it elsewhere, and maybe you can refer to that. But what I do want to focus on is the opportunity we took at that moment of friction, because there was clearly friction in the LGBT community about why we filed this case. But what we did as lawyers and as NAS, the nonprofit NGO, was say that we need to have a conversation on how this law is problematic and how we can join forces to actually fight it. And so this extraordinary journey began, which was a journey of across the country conversations, meetings, dialogues, discussions, disagreements, and debates in meeting rooms, often in YMCAs in Bombay or in Bangalore or in Delhi or Calcutta, where actually people from right across this country, queer men, queer women, people of different class backgrounds, socioeconomic status in this country, multiple languages. You can imagine the breadth of India and its diversity, and bringing all of those voices into the room to have a conversation on how this litigation should or should not be fought. And so we had this incredible process of meetings and dialogues and discussions. And what happened in that process was something which I think is salient and is something to learn from for anything where we fight for our rights and we seek to claim our rights, which is that we've got to listen to the most marginalized voices in our contexts. It's the voices of people who come from smaller town India. It's often the voices of those who are less privileged. It's the voices often, therefore, of those who are the most disempowered, who can actually tell you and convey to you what needs to be told to the courtroom and what needs to be told to the judges. And it's those voices which we were able to actually gather and marshal around to actually be able to convey the atrocity that was Section 377. What I think I can describe to you, because it's impossible to give you a flavor beyond a point, is to actually tell you how 3 or 4 ways in which this actually completely changed the way this case was perceived by the general public, by the media, but also within the community. One was this idea of collaboration and consensus. We have so many opinions, we have so many different points of view, but there was one thing we were able to all rally around, which was that decriminalization had to happen for us to start beginning to emancipate ourselves. That had to get out of the way. And so we were going to do whatever we could to actually come around and fight this case and lend our ideas and our innovations and our thoughts to the lawyers representing it, and also the rest of the community which was leading the case. The other thing it did was it demystified the law. I imagine most of you are not lawyers in this room. So words like a division bench or an affidavit or a appeal or what is judicial review, these are notions which you don't necessarily understand. And what was incredible about these meetings was that we actually discussed those notions in rooms of 80 and 100 people representing thousands and millions more. And they were able to convey some of this understanding of the law within their communities. And so what you suddenly got was a group of queer people who actually were able to understand what this completely arcane, distant, expensive, intimidating system of justice was and how their lives related to it, and what stake they had in it and what they could claim from it. And that was something empowering in itself. It was this extraordinary thing that happened. I remember a moment when we were about to be thrown out of court, we thought, on a ground in 2004 and 2005, and an activist from Madurai. And I'm talking about not Bombay, Delhi, Calcutta, Madras. I'm talking about Madurai and Guntur and Coimbatore and Chandigarh and all kinds of places and districts all over the country where people were coming in from. And one of them said that if the Supreme Court rejects us today, this was in 2005 at a critical moment, I will organize 800 people to walk naked down the streets of Madurai and Kumbakonam, because we will protest this, we will not take this lying down. And at that moment, you suddenly saw a level of empowerment which was just extraordinary. It was something which quite clearly was saying, we're not going to take this lying down anymore. We're going to actually fight and claim our rights. So that was an extraordinary thing that happened, this courage and this empowerment through the demystification of law. The other couple of things which happened were 2 innovations I can talk to you now about. One was the identifying experts. Do we know historians? Do we know great anthropologists? Do we know people from the academy? And do we know really good mental health experts who can file before the court and say, this law is problematic for these various reasons from our contexts? And we could identify, and we brainstormed and we identified that, and that came from this process of discussion, etc. The other thing which happened, which was quite powerful, was the fact that we were able to bring the voices of queer people straight into the courtroom. And let me just, unfortunately, the slide is not working. I wanted to show you one, which was the voice of Kokila. Kokila's affidavit was up on screen if it comes on. But Kokila's affidavit was one of a person who was born a male, identified as a girl from very early on, identified now as an adult as a hijra. And Kokila in her affidavit speaks of the ways in which she's just not able to live her life because, for instance, she describes the instance on Old Madras Road in Bangalore where she was actually wearing a sari and waiting just in a public space, and 5 gundas came and tortured and raped her. Someone obviously complained because the cops arrived 10 minutes later, and the cops took her into jail, not the gundas, and the cops then raped and tortured Kokila. This is the affidavit of Kokila in the courtroom. This was the voice that the courts heard. This is not the voice that a court generally gets to hear. This is not the kind of access to justice that actually occurs in our country, unfortunately. And this was the sort of voice that we were able to actually convey in the courtroom about the horrors of criminalization. That Kokila felt absolutely helpless to complain to the police, who were actually the perpetrators of the crime also, because she knew she was a criminal in her own country, because of Section 377. And so the complete disempowerment that actually 377 conveyed. So that's Kokila. The other thing which happened, which was incredible, was, you know, a lot of these ideas contributed to our victory. So some of you clearly are very young and you might not remember 2009 very clearly, but we actually got decriminalized in 2009 because of all these efforts. And we got recriminalized in 2013 by the Supreme Court in a cowardly decision, which fortunately was overturned last year. But this was 2013. This was that moment of no going back. This was the moment where the court said, where the community said, we are not going back. We are claiming this, and we're going to push ahead, and we're not. And this happened because of this collective role. You know, you can imagine a regular case. A regular case is a case of lawyers, judges, a courtroom, textbooks, and that's it. This was a lot more. This was a case of people outside the courtrooms, like I said, actually being empowered to say, no, we're citizens here, we demand and we claim our rights. And it was something extraordinary and deeply, I felt certainly deeply privileged as a South Bombay queer kid who actually is quite cloistered and lives in a pretty elite world, to actually be able to engage in this process, this incredible journey, and to learn so much from it, and just really see courage in ways in which I would never have been able to see courage. So this was another way in which I think we actually were able to push at, push for change. I think the last thing I'd like to say is on a personal note, which is that, well, before I say that, I just do want to say that for me, one of the take-home messages of something like this is that I think the journey is as important as the destination, and I think the means are as vital as the ends that we seek to achieve. And I think that if we do things in the right way, I think we will achieve. Imagine a case where a couple of gay people go to court, fight a case, get decriminalized. Is that going to really have impact in a Guntur or in a Madurai or in Bhubaneswar or wherever? Unlikely. But if you have this incredible effort where actually people participate in this incredible manner, parents got involved, friends of queers got involved, a whole bunch of, like I said, experts got involved, and then you create a momentum which is longer lasting. Today what you see is queer women going to court, queer women couples going to court, demanding injunctions against their parents who are threatening them to break off the lesbian relationship. Why is that happening? Because there's ways in which this empowerment is percolated. Today you see hijras actually taking gundas to court, to the police station, filing FIRs. You would just never see that happen in the ordinary course. So it's been quite a fascinating thing that I thought would be interesting to share with you. I'll end on a personal note, and the personal note is this. It's just deeply poignant actually to be speaking here, particularly, at a school which my parents were co-founders of. And I refer to my parents particularly because they were just the most, I came out of them decades ago, and they were just the most extraordinary. I think they've always been supportive of me and supportive of everything queer, really. And I think BIS actually was a space which allowed for all kinds of ways in which one could try and be different. It wasn't always easy, but I think there was a wonderful, certainly in my time there, in my time here, it certainly felt a lot more comfortable than a lot of the schools that other friends of mine have been to and told me about. But I also think it's deeply, deeply wonderful to be here because 18 months ago I was invited by this school to speak to Standard 5 classes, the Standard 5 class about LGBTQ people and the law. And it was just this incredible 1.5 hours maybe spent on a project that they had, and the emotional intelligence of those kids and just their sense of inclusiveness was something which was just so touching. And I said to myself, wow, if I was in the fifth and so illuminated, I'd be a pretty different person now and the world would be a better place. So it's deeply poignant to be here. It's extremely moving, and I thank you for the opportunity.